the Supreme Court has already voted, but sources say that they voted several times per issue or per section, that the 37 petitions raised an objection against. So they voted per particular issue. But let's start with one wherein Justice Marvic Leonen took to Twitter yesterday and said, mali o hindi totoo, misleading, false information, that the Supreme Court had voted or declared the entire law constitutional except for Section 4, which is the definition of terror. Let's talk about Section 4, Neri. How important is Section 4 to you?
Well, Section 4 is important because it's the linchpin, so to speak, of the entire law. Because the definition actually impacts on all the other provisions, like, for example, suspected terrorist, the definition of terrorist already impacts on you. So basically, if Section 4 is retained, if it's deemed constitutional, for example, we don't know the decision yet, so we're just thinking how it will go. But once it's declared constitutional, then the impact is already there, because whatever they do in the succeeding provisions, you can still, for example, if they say, okay, no more 24 days detention, you can be detained only for a maximum of 3 days. Still, you can be detained for 3 days on the mere suspicion of such an overbroad and vague law definition. So yeah, that's a very important provision for us.
Yeah. So I think what you're saying is, going back to the anti-terror law, even before the other sections are debated upon, it's first the definition of terrorism itself, because the petitioners actually cite the vagueness on the definition of terror, right?
Which is strange, Karen, because the definition is very broad and very vague, no? And they don't even need to really make it broad, kasi pag terorista ka, nang bomba ka, that's it, di ba? Ang ginawa nila hindi yung any crime you committed, criminal act you committed, but any act. So your act could be legal, could be constitutional, depending on your intentions or the perceived intentions ng executive or ng state security forces. You can go to prison, right? And other than that, the chilling effect, of course, you begin to second guess, is this part of the definition or not? The moment you begin to second guess, whether you're a dissenter, whether you're an opposition, whether you're media, then the chilling effect is there and the injury is there already. The freedom of expression is already stifled there. Yeah. So very important in Section 4.
What kind of clarity would you want to see on the anti-terror law? I mean, we do know that one of the inspirations for this anti-terror law was actually Australia. But then the democratic institutions, so to speak, in Australia are quite strong. The agencies are quite independent. So petitioners have said it's very difficult to model from a first world country. So what kind of provision or clarification would you want?
Yes. Well, actually, Australia was passed in the early days of the terrorism issue. So now they've actually amended their laws. So, but let's go back to us. For example, why not define the act? Say, for example, bombing, killing, you committed an act of, you massacred people, di ba? You let go of the poisonous chemical substance. Why not put in there predicate crimes? Anybody who commits the, whatever, bombing, for example, with the intention of, then that's a terrorism definition in the old law, in the Human Security Act, the one that was repealed by this new law. So for us, it doesn't need, Karen, they've always been saying, we're helpless if we don't have that definition, if we don't have that law. Karen, look, there are lots of laws in the Philippines, Revised Penal Code, special laws. Mag-bomb joke pa lang nga, Karen, kulong ka eh. How much more if you actually, put a bomb somewhere and have it exploded? So Karen, ordinary drug suspects are killed here. Patay ka na drug suspect. How much more if you're an Abu Sayyaf suspect? So all this obsession of the military and the executive of the law, we need the law, we need the law. It doesn't hold water kasi they don't really care about the law. What is the purpose of these terrorists? They don't need the law for terrorists. They will need this for the dissenters. They will need this for the opposition, but not for Abu Sayyaf, not for Maute, and whoever they call terrorists. So really, the policy issue, and I'm sure the Supreme Court debated on the policy issue, are we helpless if we don't have this law or not? The policy issue is already put to rest. You don't need this law to quell terrorism. You just implement the old law, the Human Security Act, which is already draconian, by the way. So I don't see any
But
reason
that's
for
why
this.
the anti-terror law was actually made, because the Human Security Act was deemed as ineffective.
No, actually, the only thing that they complained of during the amendatory processes in the House of Representatives was the section where they're penalized with 500,000. So a day for, mistaken arrest. So sabi ng iba doon, let's discuss that. But no, they not only deleted that provision, they went to make it overbroad and vague. Kasi tingin ko, their purpose is not really the terrorists. Their purpose is really the dissenter, which makes it difficult, Karen. Kasi whatever if for example, the terror law is upheld, the implications, of course, is very destructive implications on human rights. But more than that, it has a large implication also in the elections. You see, under the Human Security Act, the terror law is suspended 1 month before and 2 months after an election. In the new terror law, they deleted that safeguard. So it can now be used by the president. The purpose of inserting that in the old law is this. There's an outgoing president. And the outgoing president should not have the power to use terror law against the opposition. That's why it's placed there as a safeguard. Now they deleted it. So what if the outgoing president has become a lame duck? He doesn't have any candidate. He will be prosecuted by another court once he's out of office. Can he use the terror law? Of course, yes. So, if you arrest a campaigner for 24 days, not even the candidate, just a campaigner, will that it stifle the entire campaign? If you freeze the accounts of opposition groups on the pretext that they fall within the definition of terrorism, will that not be this? Really, it will derail the entire election. And in fact, for me, one of the considerations should be the implication of terror law in the coming elections. It's a very crucial elections, Karen.
Neri, are you seeing some difficulty in this, or an effect that most of the Supreme Court justices are appointed, or a big number of them, by President Duterte?
Well, I hope not, because you see, the moment they're appointed, they're autonomous. They're supposed to be independent. The president can no longer touch them. So I really hope, it doesn't hold sway that whoever appointed me, I'll be loyal to him or her. The issue of terror law, Karen, is beyond temporary loyalties to temporary presidents. Presidents come and go, Karen, but the terror law will impact on the next generation of Filipinos. It will impact on our children, our children's children. So I really hope that the Supreme Court will decide on the basis of merits rather than on their appointing powers where they're beholden to.
And let's just clarify, if the decision of the Supreme Court is not favorable or does not satisfy the petitioners, you will have an opportunity to file a motion for reconsideration on specific points.
Yes, Karen, definitely, because we believe ang lakas talaga ng kasos sa anti-terror law. For me, of course, I'm speaking as petitioner of counsel. But talagang, open and shut case in the sense na, talaga yan? It's really unconstitutional. So the moment that there is a declaration this certain provision is constitutional, we will have to challenge it through a motion for reconsideration. We owe it to the Filipino people. Ilaban talaga to the hilt. And hopefully, hindi ito magamit talaga sa dissenters and media and opposition, not just during the elections, but even after.